This afternoon, this conference, this moment is one of those few moments where memories and possibilities meet. In 2019, when we lost Adavize, we knew we had to honor him in a way that represented his brilliance, his passions, and his generosity of spirit. And that's how the Adavize Alao essay competition was born, an idea that has since grown into a movement. Nearly 1,000 young lawyers and law students have sharpened their voices through thought leadership in privacy and data protection, a field that Adavize cared very passionately about. This year is especially meaningful as Lawyer marks its 10th anniversary. We've expanded the symposium into a full conference, and welcome to the pilot of it. And we did this right here at Obafemi Awolowo University, the place where it all began. Adavize himself once walked these grounds as a proud member of the Law Student Society and Equity Chambers. It feels like coming home. Being here, remembering Adavize is deeply personal to a lot of us. So with reverence in our hearts and a little bit of thrill in the air, it is my honor to announce the winner of the 7th annual Adavize Alao writing competition. Presenting the award with me would be Toby Adeborale. A round of applause for Mujeebat and Moyosore Idris.
We are very happy and very excited to have the winner for the Law Students category with us this time around. And she's traveled all the way from Abeokuta Crescent University to join us. At least, Owen did not win, so nobody can accuse me of partiality or anything. I'm going to step aside a bit for Moyosore to give us a short overview of the essay she wrote. As part of what we're doing, which is raise new experts in this field, we want people who are able to speak to the things that they talk about, and then they may be able to also address any concerns that people have regarding the topic. So I'll just step aside for Moyosore to give a short presentation of the essay topic she wrote on.
I remember the first time I created a social media account. I was probably too young and all of my friends were doing it. It felt like a private club, a digital tree house where I could hang out with my friends, share silly jokes, and post photos. What I did not realize back then was that our tree house had no wall, and we were basically performing on a stage with an invisible audience of unimaginable size. Esteemed audience of distinguished ladies and gentlemen, it is an honor to stand before you today to present my essay titled, Can Online Platforms Safeguard Youth Privacy? My essay explores the realities of growing up in a digital world and questions whether the platforms we trust with our lives can truly protect our privacy as young people. When we ask this question, can online platforms truly safeguard youth privacy? We're asking if companies like Meta, Snapchat, and TikTok have the capacity and, more importantly, the willingness to protect the personal information of their young users in Nigeria from an invisible audience. Based on my research and perspective as a young Nigerian, my conclusion is that the architecture of these platforms makes them fundamentally incapable of being reliable guardians of our data. So let me explain my conclusion by defining the key terms. We'll start with the invisible audience. It's a term that describes the hidden world of data brokers, advertisers, and even algorithms that watch, collect, and use everything we share online. In the legal sense, youth privacy refers to the right of young people, particularly the minors, to have the processing of their data controlled through the verifiable consent of a parent or a legal guardian, as stipulated under Section 31 of the Nigerian Data Protection Act 2023. So why did I reach a conclusion that these platforms fail? First, the business model is a problem, and I cannot recall where I read this, but if you're not paying for the product, that means you're the product. Platforms like Instagram and TikTok, they rely on advertising, and to help a company say, target Nigerian teens interested in Afrobeats, then the platform needs to collect everything about us. And this creates a fundamental conflict, which means that protecting my privacy means collecting less data, which hurts their profits. And as Shoshana Zuboff outlines, this is the core of surveillance capitalism. I mean, you cannot tell a farmer to pray against a rain. That's not possible. So second, our Nigerian Data Protection Act is a shield, but then it has limits. Pursuant to Section 31 sub 2, it sets the age consent at 18, requiring parental permission for minors. It also established the Nigerian Data Protection Commission as our regulator. But my analysis reveals weaknesses, and unlike the UK specific design code, our NDPA is still quite principle based and it lacks hard rules on issues like privacy by default. Also, the Commission is new and then it faces huge tasks regulating global tech giants. The law is a good foundation, but then the house is not fully built. So this leads to two major unresolved challenges that support my conclusion. We start with the age verification paradox. The law protects children, but how does the platform know that I am a child? Pursuant to the NDPA, I should be protected, but I can just lie about my birthday, right? I'll just type a fake year and then all the protections vanish. Then the second one is the algorithm black box. And it is important to note that the most hidden part of the invisible audience is not human, but the algorithm. Take, for instance, when I scroll on YouTube, and when I scroll on YouTube, the algorithm watches what I pause on and uses it to decide what to show me next to keep me hooked. So if I watch a sad video, it might push me towards a more extreme content, and this is a major legal challenge. How can the NDPC regulate a black box that a company calls a trade secret? Now, platforms might defend themselves. They'll say, oh, they provide free and valuable services, and strict rules could stifle innovation. But from my perspective, this defense fails. Innovation cannot be an excuse to exploit our data. The duty of care, as envisioned by the Nigerian Data Protection Act, must lie with the platform, not with our parents constantly trying to be on guard. So my conclusion is this, that we need a multi-pronged approach, and the NDPC must be strategic, and it should partner with civil societies like the Paradigm Initiative to amplify its impact. And most importantly, digital literacy should be woven into our school curriculum as a subject on its own. In final conclusion, ladies and gentlemen, the invisible audience is a permanent feature of our online lives. And while the Nigerian Data Protection Act 2023 is a welcome first step, my research lead me to find that it is not enough. And without tackling the issue of age verification and the black box algorithm, this audience remains, and trust me, it can be very hostile. So our privacy will not be gifted to us by platforms. It must be claimed through well enforced laws, smart enforcement, and a smart generation. Thank you very much.